maximum fine in an F4 is 5,000, right?
Right.
You guys are already right?
Yep.
Yeah, a second. All rise.
Be seated. Ms. Bell?
Thank you, Your Honor. We're here today in the state of Ohio versus Devin Jackson, case number 23-CR-623. The defendant is present with counsel, Rachel Smith. We're set today actually for a jury trial. However, it's the state's understanding that the defendant is going to withdraw his previously entered plea of not guilty and enter a guilty plea to the indictment, that being one count of receiving stolen property, a felony of the 4th degree. On Friday, that was January 3rd, a request for intervention in lieu of conviction was filed, and the state has no objection to that motion. Thank you.
All right, Ms. Smith?
Thank you, Your Honor. The client's intent is consistent with that, which has been outlined by the state, and he does intend today to withdraw his previously entered plea of not guilty to the indictment and enter a plea of guilty to the single count of the indictment as charged, with the understanding that upon the court's acceptance of his guilty plea, he'll be admitted into the intervention in lieu of conviction program.
All right, so it's been represented to me that he has no record. Is that correct, counsel?
That's correct, Your Honor.
Okay. So if that's the case, then we'll deal with the intervention motion at the time of the, when we bring him back. And if that's the case, then I'll grant it at that point in time. All right, Mr. Jackson, how old are you?
I'm 20.
How far did you go through school?
Graduate.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of this indictment?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
All right, now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question or you want to talk some more to Ms. Smith, let me know and I'll give you more time. Do you understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
And if you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to this charge?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, Your Honor.
Do you understand that by pleading guilty to this felony, that if you end up getting convicted, that you are voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control?
Yes, Your Honor.
All right, now, receiving stolen property is a felony of the 4th degree. It carries a maximum prison sentence of 18 months and a maximum fine of $5,000. Do you understand that?
Yes.
Do you understand that if you are convicted of this offense and are sentenced, if a prison term is imposed, then you might have to serve a period of post-release control under the parole authority for up to 2 years?
Yes, Your Honor.
If you were to be placed on post-release control and violated any conditions, the parole authority could return you to prison for up to 9 months for each of your violations, up to 1/2 of my sentence. Do you understand that?
Yes.
If the violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, Your Honor.
And the maximum prison term for that violation would be the greater of 12 months or the time you have left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term were to be imposed, that you are eligible for judicial release?
Yes, Your Honor.
If you are convicted, you could be placed on community control for up to 5 years, but if you violated any conditions, I could send you to prison for 18 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty?
No, Your Honor.
If it comes to sentencing, has anybody promised you what I would sentence you to in this case?
No, Your Honor.
Do you understand I would not have to accept the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Ms. Smith before pleading guilty today?
Yes, Your Honor.
Has she discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No questions, Your Honor.
All right, Ms. Bell, if the case went to trial, what would the evidence show?
Thank you. Your Honor, the evidence would show that on May 20th, 2023 in Menor Lake County, Ohio, Devin Jackson was found to have in his possession a 2018 Honda Accord bearing Ohio registration KBW 1692. That Honda Accord belonging to one Amy Reedy. And Devin Jackson did know or have reason to believe that that vehicle was obtained through the commission of a theft offense, and that vehicle was a motor vehicle as defined in section of the revised code 4501.01. Thank you.
Thank you. All right, Ms. Smith, anything to add to those facts?
No, Your Honor.
All right. Mr. Jackson, did you hear what Ms. Bell said, that the facts would show if the case went to a trial?
Yes, Your Honor.
And are those facts true?
Yes.
All right, what is your plea to receiving stolen property, a felony of the 4th degree?
Guilty.
All right, Ms. Smith?
This is the plea that we went over in the hall with the exception. This page is different, but we talked about how it would be different. So instead of attempt, it's receiving stolen property as you were charged a felony of the 4th degree. Maximum of 18 months, not 12. Maximum fine, $5,000 or $2,500. Okay. Your Honor, I have in my hand the written plea of guilty, which I did have opportunity to review with my client prior to coming on the record. I did witness him sign the document, and I have affixed my signature to the same.
Your Honor, I also witnessed the defendant sign the written plea of guilty and sign the same.
Mr. Jackson, is this your signature on the written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
All right, I'll accept the written plea of guilty. Defendant was present with Ms. Smith, advised to follow his rights. In a knowing, intelligent, voluntary waiver of those rights, he understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept his plea of guilty. And I will stay the criminal proceedings pending the hearing on the motion for intervention, and that will take place on February 5 at 9 a.m. I'm going to refer this for a pre-sentence report, a drug and alcohol evaluation, and a victim impact statement. And the bond will be continued. Now, Mr. Jackson, Ms. Smith tells me you're going to test positive for marijuana. Is that correct?
Yes, Your Honor.
When is the last time you had that?
Our last court date here.
Okay. Now, you know that's a violation of your bond, right?
Yes, Your Honor.
Okay, so why were you doing it?
It helps with my anxiety, and it just helps me get up and start moving.
Okay, so you're gonna go over, you're gonna get tested today, it's gonna come up positive. Usually I revoke the bond, I'm not gonna revoke it at this point, but when you come back for another interview, then I better see the level of that test on the decline rather than where it
Yes,
is
Your
today. Do you understand that?
Yes, Your Honor.
All right, anything else, Ms. Bell?
Nothing further, Your Honor. Thank you.
Ms. Smith?
Not at this time, Your Honor.
All right, we're adjourned.
All rise.